Hello everyone and welcome to this video tutorial in which we're going to be looking at a suggested answer for a contract law evaluation essay, and the topic for today is offer and acceptance. So if you've been struggling with knowing how to tackle an evaluative essay on this area, then hopefully this video will be really useful to you. And if you do find it useful, I'd be really grateful if you would hit that like and subscribe button because it really helps me out in producing new content. Let's take a look at the essay question then. So whichever exam board you're with for A-level law, if you're studying contract law on one of the papers, and it will vary depending on the format of your particular exams, but you will be asked to evaluate the law on contract, and that could be any of the contract topics, and I will make some more videos on other areas, but today we're going to start with the first topic in contract law, which is the law on offer and acceptance. And this is an example question of the type of thing that you might be asked. Now I'm looking at the Educast board for this particular one, so this question would be out of 25 marks if you were with Educast, and it would be on component 3 or exam 3 for Educast. So the questions can be phrased in any way really, but they'll all typically come down to, when you're looking at offer and acceptance, you'll be asked to discuss whether it's difficult to find precisely where an offer and acceptance has occurred in a contract. Whilst to the layperson, they probably think it's easy to see whether there's been an offer and acceptance if they've not studied law. When you're a law student and you've looked at the area on offer and acceptance, you'll know that there is a huge number of cases that you need to look at, and lots of different rules to help you decide whether an offer's been made or not, depending on whether it was said verbally or whether it was written, and whether it's being accepted, and all the different rules to do with acceptance by post or whether the acceptance was delayed, etc. So there's a huge amount of law in this area. So a very quick answer is yes, it's actually really difficult to find if there's been a valid offer and acceptance in a contract. But obviously we need to look at how would you write that in an exam to really maximise your chances of getting full marks. So I've got an essay here, I'll just scroll down the page so you can see. And what I've done this with a few videos, is I've colour coded it, and we're going to take a look at it together. But the black font is where I'm talking about facts or rules, and that is, if you're with Educast, Assessment Objective 1, AO1. That is knowing the content, your cases, your facts. The red font that I've got here is signalling that there's AO3, Assessment Objective 3, or that's evaluative comments. And that's where you are either praising the law or criticising the law, you're giving a view on it. And the red font is obviously really important in an evaluative essay where you're being asked to discuss something. And just to make it easier for you to see on this recording, I've also highlighted in yellow cases that I'm using in this answer. So to get a high mark on an essay like this, you need to do two things. You need to show that you know what the law is, your AO1, your facts, your rules, your principles from the cases. And the second thing is your AO3. You need to show that you can evaluate the law. You can discuss the positive things about it and also the challenges that it throws up. And it can be quite useful when you're revising to colour code or to go in and highlight your essays in different colours like I've done here, because you can see at a glance, hopefully there's a balance. And what you'll typically see in this essay is that there's some facts, there's some evaluation, there's some facts, there's some evaluation. And by doing that, hopefully you're maximising your chances of getting high marks. So if we take a look at this answer then, it starts off with an introduction, and it's always nice to refer to the question in your introduction. So in order for there to be a binding contract, we have to have a valid offer and acceptance, consideration and intention to create legal relations. And firstly, we need a valid offer and acceptance. And I'm referring back to the question here that's asking me, is it difficult to find the offer and acceptance? By saying that although this sounds straightforward, contracts are formed in a variety of different ways. And because of that, finding where an offer and acceptance has happened is difficult. And you can talk about contemporaneously signing of a document, shaking hands. There might be different verbal cues, nodding. We've got computer technology, emails, maybe text message communication. All of the different ways that we communicate is going to make it difficult to find whether there's been a valid offer and acceptance. So that's the introduction. And then in the next paragraph, you can see that there's a definition of what an offer is. So starting with an offer, that's logical to start there. It's a statement of willingness by an offeree to enter into a legally binding agreement, based on the terms made by the offeror. And the contract's going to be formed when the terms are accepted. And again, there's some evaluation in red here. The difficulty is determining whether an offer's actually been made. And you can see that the essay then goes into discussing the rules on invitation to treat. And this is where confusion often arises, because an invitation to treat is merely inviting offers. So goods displayed on supermarket shelves are generally invitations to treat. And when the customer picks up the goods, that's not an acceptance, but that's an offer to buy on the part of the customer. And I've got a case here that supports this, Fisher and Bell. And I've given the principle or the ratio from Fisher and Bell, that's in black because it's a fact, and then I've evaluated that case. So I've said that this is confusing to the general public because the general public would probably think that a price tag on an item is an offer and that's accepted when you pick it up. And then we've got Partridge and Crittenden, again, the principle from the case. I'm pointing out some evaluation here that it's not always the case that an advert will always be an invitation to treat. And you could use Carlyle and Carbolic smoke ball there. And there again, some more evaluation. So the distinction between bilateral and unilateral contracts is going to be important. Auctions are also another complication, and you could talk about British car auctions and Wright there. And that further complications still have arisen where goods have been advertised by tender, such as in the case of Harvella Investments and the Royal Trust of Canada. Another difficulty that you could discuss is that when a statement of price is made, that can cause confusion as to whether there's going to be offer and acceptance. And you could use Harvey and Facey here. And sometimes it's useful to mention facts. Remember, in law, generally we focus on the ratio and the facts are largely irrelevant. But particularly in contract law, sometimes some of the facts are helpful to help you illustrate the point. So we've got this conversation between Harvey and Facey, where Facey has said lowest cash 900, and then there's a telegraph back. And it was held that Facey's telegram was an invitation to treat and not an offer. And again, that illustrates the complications in working out precisely which of these communications was an offer. You could talk about the fact that sometimes offers are vague or uncertain, like Guthing and Lynn, which was talking about a lucky horse. And that if the terms are certain, we still have to have communication of this offer to the offeree. It can also be revoked at any time until it's accepted, Routledge and Grant. And of course, that can be problematic if the offer's been revoked, but that's not being communicated effectively to the offeree. We've also got the issue of lapse of an offer from Ramsgate Victoria. And again, typical in law, it's unclear what a reasonable amount of time is. And there's uncertainty about whether a contract might be formed if the offeree accepts an offer in ignorance, i.e. they don't know that the person who offered has since died, Bradbury and Morgan. The essay then goes on to look in more detail about acceptance. So the first rule is that acceptance must be unconditional, and any attempt to change the terms is going to be a counteroffer, and that comes from Hyde and Wrench. And it's not always to see in negotiations whether a counteroffer is being made or whether simply they're requesting further information, and you could use Stevenson and McLean to support that point. We've got more complications with acceptance if it doesn't comply with the specific form. So if the person has said you need to accept by email, and then someone tries to accept by another method, and that comes from Yates Building Co. And we can have particular problems known as battle of the forms, where each party is trying to submit on their own terms using their own forms. And you can see that in the facts of Butler Machine Tool and Excello Corp. And that case gave us the rule that the last shot rule generally applies. But an evaluative point you could make about that is that's not necessarily always going to be fair. Another problematic area with acceptance is that the courts have to decide at what point a contract's formed where acceptance was made by post, and they came up with the rule in the case of Adams and Lindsell. That's where we get the postal rule from. There was a valid contract which came into existence the moment the letter of acceptance was placed in the post box. Now that rule can be harsh, so an evaluative point there, and you could use household fire and carriage to support that. And the courts have also struggled where we've got more modern methods of communication. So rather than using letters in the post, you could use the case of Entores here to talk about the fact that Denning looked at the postal rule and he said it didn't apply for instantaneous means of communication such as telex. And instead, acceptance occurs where the message of acceptance is read. So that's a different rule, making it further complicated. And then Thomas and BPE solicitors, Blur J said that the postal rule applied to an email and that with an email it was effective from the moment it was sent. However, and this is where we've got some evaluation coming in, Blur J made it clear that there's no clear-cut rule, and the outcome in each case will depend on the context, including the intentions of the parties, and this was his wording, sound business practice. Of course, that's extremely vague, and ultimately then, we don't really know what the rule is for accepting by email, offers and acceptance by email. So, a little conclusion here. It's apparent that it's very difficult to find exactly where an offer and acceptance lie in negotiations for a contract. Some critics have argued in favour of abandoning the rules and asking simply, do the parties consider themselves bound? So in the conclusion there, you can see I've referred back to the question that it is very difficult to find exactly where the offer and acceptance have lied. And it's also nice in your conclusion, particularly if you're criticising an area of law, to suggest a possible reform. It's not to say that this reform's a great idea, but it's an alternative. So rather than just critiquing the law, we're suggesting how it could potentially be changed or improved. This is a little mark scheme if you are with Educas, for you to have a look at whether your knowledge falls into the top mark band for 8 to 10 marks and whether your analysis and evaluation again falls into the top mark band. If you're with a different exam board, you can ignore that completely. And as I said at the start, whichever board you're with, the law on offer and acceptance and the critical comments that you make about it are going to be the same regardless. So I hope this video has been really useful to you on evaluating the law on offer and acceptance. As I said, if you can like, if you can share, it really helps me to make new content. And I'll see you in the next video.